Item number 1, pronouncement of judgment.
We have held that in view of the judgment of the Supreme Court in Aries versus Tamil Nadu Electricity Board, 2018-12 SCC 393, the facts of which are absolutely similar to this case, the objection regarding limitation fails, but on merits, the claims are dismissed as totally untenable and also untenable because of inordinate delay in lodging the claim after final payment, except the respondent plaintiff shall only be entitled to a refund of the security deposit of 599,613 with interest at the reduced rate of 7% per annum from the date of filing of the suit till payment. The order for payment of costs is set aside. The impugned judgment and decree is modified to the above extent. The appeal is partly allowed to the above extent.
Item number 2 and 3.
May it please your lordship. Lordship, by the order dated 22nd 10/24, your lordship, we have deposited 20 lakhs. That will take back that money, your lordship, with the registry. We have deposited with the registry, your lordship. Lordship will kindly grant us the permission to.
Please take down after pronouncement of the judgment. It was submitted by Mr. N.D. Chulai, learned AAG, that the appellant has deposited rupees 20 lakhs
Lordship.
with the Registrar General
Lordship.
of this court. This deposit may be made over to the appellant number 1 by the Registrar General within 2 weeks of communication. of this order.
Lordship.
Then again you put to, both of us will sign.
May it please, George.
Yes. Which one? Yes. Yes, please.
Inspection has been carried out by the Court Commissioner, my lords. Report has been filed.
You are the court commissioner?
My lord, I'm being led by Mr. Jishnu Shah, who's appearing online, lordship.
Yes.
Mr. Kishore C.H. Gautam was the Court Commissioner appointed by your lordship.
Yes.
So he has filed the report
Yes.
and copies not with us, my lord.
Have you circulated copies?
Because
Where is the commissioner?
Commissioner is not,
My lord, we have not received the copy.
we have not received the copies, my lord. So,
But you were present at the meeting.
yes, it was, in fact, it was, request was also made to the Court Commissioner to circulate a copy of the report, but he said that only after your lordship's order, it will be circulated, my lord.
No, it is all right, but then you have no grievance with regard to the conduct of the proceedings by the court commissioner.
Yes, we have no.
No, we don't have.
We have no.
My lord, only one thing, my lord, if I may add. My lord, when your lordships passed, my lord, the order by which the court commissioner was appointed, your lordship directed status quo to be maintained in respect of block A. That was on the basis of the submission made by my learned friend that the subject matter of the agreement between the parties was only block A. And my lord, we unfortunately were not equipped with the documents on that date. But my lord, I have, my lord, with your lordship's leave, I will, my lord, ask my junior to hand up to your lordships a copy of the, my lord, site plan and agreement that was made over, my lord, by the state to us. Well, it is unfortunate that, my lord, completely wrong submission is made to court, and on that basis, my lord, the order is, my lord, restricted to block A, when, my lord, in fact, all 4 blocks were handed up. Lord, may I just request your lordships to kindly have a look at this, my lord, one document.
Your Lordship, the inspection report, the court commissioner has inspected
All right.
the entire premises.
You were licensing your block A only.
No,
There was
my
no
lord, that
license,
is, my
Lord.
lord,
Even there was
mistake.
no license. My case is that no
My lord,
license
that
was
is the
granted
wrong
to them.
submission that is made. Please see, my lord, how, my lord, the court state is misleading the court.
I would say that they have misled the court, my lord. I will show from the, they did not
One
have.
minute, 1 minute.
My lord, please just have a look at the document that the state made over to us.
No, but
I don't have
your client should know which area your client was in possession.
Blocks A, B, C, and D. My lord, this site plan was made over, my lord, consequent on the license granted to us.
Plan.
And my lord, in respect of the entire area, kindly see buildings 1, 2, 3, and 4.
Nothing. My lord, the agreement said, my lord, that the land will be, on land they will construct the building and they will utilize that building.
My lord, kindly see, my lord, what is the existing
They were in
building.
occupation of block A or
Your lordship, there was a huge building and one portion of the building, that is block A, they were having their machines and apparatus, my lord.
Well,
That
kindly see the-
possession on 19th March, my lord. That possession was taken by us on 19th March. Their prayer before your lordship is to restore the possession also, my lord. Possession was taken
Restore the
on
possession of
19th
the
March.
entire
And when
licensed
your
area.
lordship passed the order on 9th April, my lord, your lordship said maintain the
Please see,
status quo. We
kindly see,
maintain
my
the
lord, what
status
was
quo,
this
my lord.
document?
Mr. Shah, not two together. It is we cannot hear.
I'm very sorry.
We cannot
I'm
hear
very sorry.
either.
I'm very sorry.
We will hear you. Yes.
Yes, my lord. So, 19th March 2025, I have taken the position. I have taken the position, my lord, on 19th March. That is the admitted fact. Their prayer before your lordship is that hand over the position in their appeal, my lord. On 9th April, when matter came before your lordship, on 9th April, your lordship directed maintain status quo. Position was with us on that day, and your lordship further said in the your lordship's order.
Which block? Block A.
And the entire building was with our position, which had 4 blocks. In block A, their components were there, their machineries were there. Your lordship directed the court commissioner to go and inspect block A and find out their
No,
equipment.
but who was in possession?
And I was in possession of the entire building. They were my licensee. They were utilizing one block only.
No, but were they utilizing B, C, and D also?
My case is that they were not utilizing because I have the material. Because entire equipment was my case. According to us, they were in a block A, and your lordship will see the court commissioner report also.
No, they were utilizing maybe, of course, pursuant to a license or
Pursuant to a license under which they were required to construct the entire building on a piece of land. In this agreement was of 1999. In 2022 and 19 and in 2022, my lord, it started utilizing entire half of the equipment is of the state government. Then the issue came, my lord, that we did not enter into any agreement with the petitioner. There was no MOU with the petitioner, my lord. It's an admitted fact that there was no MOU with the petitioner. Petitioners step into the shoes of partners. There are 2 partners.
so the entire building is A, B, C, D.
The entire building is A, B, C, D. There are 4 blocks in the building. So they were having their entire equipment in block A.
So either we or the learned arbitrator has to go into this question of
Yes.
of who was in possession.
Yeah.
So A, B, C, D maintain the status quo.
Your lordship, I would request one. I will make one submission. Your lordship will. We are bound down to the orders. Now, issue is, my lord, that if your lordship will see the report of the commissioner, my lord. In report of the commissioner, your lordship will notice that the entire equipment is in block A. The agreement has already been terminated way back in January.
No, but B, C, D are vacant according to you.
And B, C, D are vacant, my lord. I have the photographs and
All
construction.
right, but keep them vacant. Don't bring in anything.
I am not bringing anything. What we are doing is, my lord, let me inform the court. What we are doing is that since this is attached to the civil hospital, my lord. Civil hospital has been utilized. This hospital is being utilized for a medical college, my lord. It is part of the civil hospital. So BCD are being utilized for the purposes of classroom, etc. Because inspection will be carried out, and they do not have anything in A. And there is no document showing that we handed over the entire building to them. There is no sheet of paper also, my lord. So if they are having A, we will not touch anything. till your lordship hear the matter finally. We will not do anything, but permit us, because BCD are empty, my lord. They are not going to get any advantage. Their whole claim in the entire petition is 5 crore rupees. We are ready to deposit that amount also, my lord. We have no issue. But what their interest is, what they are filing a FIR against it, their interest is to block the medical college. And medical college, which is going to benefit everyone, including them also, if they succeed, if the lab will come out, my lord. If they don't succeed, my lord, that premises will be utilized.
Mr. Shah, your claim is 5 crores.
No, my lord. My claim is for specific performance of the agreement. My lord, I am challenging the wrongful termination. The agreement was entered into in respect of, my lord, A, B, C, D. My lord, that is 1, 2, 3, and 4 buildings which your lordship filed in the site plan. Now, my lord, initially I had, my lord, moved the Section 9 application. I obtained an order of injunction in respect of the entire plot. Now, my lord, the order of injunction, my lord, did not, my lord, survive, my lord, for a short period of time because of, my lord, certain closures of court. My lord, during which time, my lord, it was, my learned friends went and forcibly took possession. I filed an application for repossession. The application for repossession was allowed. But then, my lord, without giving us repossession, my learned friends came to court and said that, look, my agreement is not with entity A. Entity A has got the order, my agreement is with entity B. Well, that is, my lord, when I came up in challenge before your lordship. Now, my lord, your lordships have directed status quo to be maintained. My learned friend represents that the subject matter of the agreement is only, my lord, block A, which is completely incorrect. Well, that will be borne out by their own site plan. And, my lord, my learned friend says that, my lord, the commissioner has gone, commissioner has found this and that, but we don't have the commissioner's report yet. My lord, your lordship has fixed the matter for final hearing on the 14th of August, 14th of May. But till then, at least let status quo be maintained in respect of all the 4 blocks, and, my lord, we shall come back and argue the matter.
Who's the arbitrator named in the agreement?
Your lordship, there is no, they have simply notice and no arbitrator. Your lordship may appoint the arbitrator. We are ready to go before the arbitrator also, my lord.
You agree on one?
Any whatever your lordship suggests,
anyone your lordship appoints,
suggest we will
for the purpose.
But the only issue is, my lord, that there is no agreement with this party. The learned commercial court held that it is not a signatory to the arbitration agreement. So if it is not a signatory to the arbitration agreement, they have no right to claim status quo also, my lord. First, their right has to be decided whether they are party to the arbitration agreement or not. And the fact of the matter, my lord, that there are 2 partners. In fact, our agreement is with Salvia Global LLP, and they are not before your lordship. MOU, if I can, your lordship, the MOU, your lordship kindly see the MOU. That MOU, my lord, the Salvia Global is not before your lordship. They have not challenged the termination order also, my lord.
That is, my lord,
Whatever, Mr. Advocate General, whatever is the status quo, you maintain till we hear the Section 9.
Yes.
And try to agree with Mr. Shah on an arbitrator. Better if you agree. Because if the court suggests, sometimes the parties are a little embarrassed to say, no, we don't want
no, we agree, your lordship, because and only problem is, my lord, that I will agree to the arbitration with the party with whom I have signed MOU. He is a stranger to the contract, and that is what has been held by the commercial court, and on that ground only it has been dismissed. So first he has to show that he is party to the agreement, my lord. If he is not party to the agreement, I can't agree with him on arbitration. I can certainly agree with the arbitration with Salvia Global LLP, with whom I have signed the.
Your lordship submitted the matter on the 14th. Well, let me argue it out. The law is clearly well settled now. I can convince your lordship
first,
that
threshold they have to cross. Hurdle they have to cross.
All right.
The only thing I was praying, my lord, the report has to be circulated to us, my lord. Yes. That is one. And second, my lord, that they have filed in this volume, and certain documents have also not been filed, which are before the commercial court, including my submission and my reply to Section 9. And the certain orders of the trial court have also not been filed, my lord, along with this, my lord. So I was seeking, my lord, 1 week time, and your lordship may have it on 15th or subject to convenience of learned senior advocate, because we will require 1 week time because the entire documents have not been filed along with the paper book.
It's a very short question, very, very short question with regard to the party. Well, I don't think that requires any affidavit, any document.
Because
law, I can
my reply, which is there in Section 9 application before the trial court, has not been filed, Mr. Sir. Difficulty, that's the matter of court record. I don't. And that court has referred to that my reply and contents of the same for rejecting your application. So that has to be on record.
Well, I don't mind if my learned friend brings on record anything that was before the trial court. Well, I can rely on a copy. We can go ahead with the hearing on the 14th.
I was praying that let this matter be fixed on 15th, my lord, for final hearing. We have no issue.
You have difficulty on 19th May?
19th may have no issue. We can have on 19th.
I have no difficulty. If your lordship wants
19th
hearing
May. 19th May.
List both the applications on 19th May.
well,
Hello.
let status quo be there for all 4 blocks.
The special officer appointed by us on 25th April 2025 has visited the subject premises made an inquiry and inventory of the goods lying thereat. Subject premises bracket block A. And has filed a report in this court. Next, let a copy of this report be circulated by the special officer to all the parties by 12th May 2025. Paragraph. Paragraph. The controversy now before us is this. Paragraph. Next line. According to Mr. Shah, learned senior advocate, appearing for the petitioner, under the agreement between his client and the respondents, not only block A, but not only block A, but block B, C, and D were also allocated to his client to carry on business. Full stop. The subject matter of the proceedings not only the subject matter of the proceedings includes blocks B, C, and D also. Blocks B, C, and D cut out also in addition to block A. Next line, Learned Advocate General submits that the equipments of the petitioners were in block A and blocks B, C, and D were always vacant. Full stop. His client is now utilizing those blocks to run classes of the adjacent.
To construct the classrooms, my lord.
And construction is going on at present.
Construction classrooms for medical college.
To construct classrooms
Changing the nature and
for the
Proposed medical college.
students of the adjacent medical college. Full stop. He says that those units were never in the possession. Those units were not
Utilized.
but they were granted, they were allocated to them.
There was no what has happened, my lord, if I will take your lordship to the documents, there was no allocation. There was no allocation at all. Not a single sheet of paper allocating them in Pasture Institute, my lord. There was no document, my lord. If they say that they have been allocated, I'm out.
Were not allocated those portions, and they were always in the possession
Constructive position of the state government, my lord. Yes.
of the state. This again is denied by Mr. Shah, who maintains that under the agreement, all the blocks were made over to his clients, and that these 3 blocks, B, C, and D, happen to be vacant. Paragraph. The question has to be gone into either in the Section 9 application or in arbitral proceedings between the parties. In those circumstances, we direct the special officer already appointed to take symbolic possession of blocks A, B, C, and D. We restrain the parties from creating any third-party rights in respect of those areas. The respondent shall for the time being not proceed with further construction in blocks B, C, and D. Full stop. Status quo regarding possession of all the 4 blocks shall be maintained until further orders.
I was praying, my lord, that under the specific relief act, my lord, this is an infrastructure project. So there can be there is a bar in law, my lord. If I can show one provision of specific relief act.
What is the bar?
Bar is, this is a medical college which is under, because they are seeking injunction, my lord, from your lordship. Injunction from us from constructing anything, doing on our piece of land, which we have not formally allotted to them. They had some utility, utilizing certain premises, my lord. The specific relief act clearly says, my lord, that there can be no injunction in respect of the infrastructure project. My lord, if I can show that. I have no issue that injunction is granted qua A, my lord. B, C, D, my lord, permit us if they, because this will be a kind of irreparable loss to us. If we succeed, our batch will be gone for this year all. We will not get the batch for 50 students. We are not getting any benefit out of this, my lord. So please permit us to, for B, C, D, for rest of the thing, we will maintain status quo, we will maintain.
No, but see, you want to do the construction.
We want to do, we will not create third party.
What construction?
We are remodeling the existing structure in classroom. We are putting benches, we are creating, within that, we are not demolishing anything. This is, and if you also will see one provision, because there is a clear bar in law that they cannot seek the injunction against infrastructure project, my lord. In law, there is.
I have not.
Yes, a specific relief act. Kindly see a specific relief act. Recent amendment, because this was the problem which was happening, my lord. Your lordship, kindly see section 20 capital A. This is a recent amendment, my lord. with effect from 2018, my lord. No injunction shall be granted by a court in a suit under this act involving a contract relating to infrastructure project specified in the schedule, where granting injunction would cause impediment or delay in the progress or completion of infrastructure project, my lord. And for the purpose, explanation for this purpose of this section.
Which section you are reading? Section?
Section 20, capital A, my lord. Lordship got it. 20A inserted with effect from 1st October 2018. No injunction shall be
This
granted.
must be a project for the public at large.
Yes, it is a
Like
project.
a bridge, highway or something
Your
like that.
Lordship, kindly see the schedule. 5C, schedule, Your Lordship. Medical college is included. And 41HA also, my lord. Kindly see 41HA and then schedule, my lord. (41HA) injunction when refused. If it would impede or delay the progress or completion of any infrastructure project or interfere with the continued provisions of relevant facility related to thereto or services being subject to matter of such project, my lord. And then kindly see the schedule, my lord. Next page, your lordship will notice at the top of the page is section 20A, capital, section 20, capital A, and 41HA, and your lordship will kindly see 5 of the schedule. Five is social and commercial infrastructure, and C, your lordship will kindly notice, C, hospital, capital stock including medical college, paramedical college, and diagnostic
Mr.
center.
Advocate General, infrastructure is the building. This what you do is the superstructure.
In this,
This is not the
in the, because, my lord, this building, my lord, the medical college is being established, my lord. Now,
Well, let's kindly
So
see
we will say
section
that,
20A.
temporary and removable.
a temporary, we
And removable.
we
That's
will
all.
do that, my lord. We will not adding anything inside the room, my lord. But for
Or that you say that they can only proceed.
Well, let's kindly see section 20A. It says no injunction in respect of a contract concerning infrastructure projects. Where is the contract? Well, this is when one party to a contract, well, it seeks an injunction restraining, well, ultimately the commencement of the proceeding with an infrastructure project. Well, the section is being turned on its head. There is no
section
contract.
41, if your lordship will see,
Anyway,
Kindly see
may proceed with creation of classrooms in blocks B, C, D. But any construction shall be confined, shall be strictly temporary and removable in the event the petitioner succeeds.
Yes, very well. Very grateful.
Detail number 4 and 5.
Very grateful.
Yes.
Give me those pages. What is that? 89.
Nineteen 8 SCC 227 was the last decision.
Balance. That was on that
And you
doctrine of
place the summary of the law
balance.
in para 13.
Balance. Only other issue that remains, Balance, is that of Article 14. Balance.
Yes.
When they went on to create, Balance, the law which created for a CBW from 45 bonds, Balance, they decided that we create another entity that's called a CBW. To that extent, it's just two decisions I'll place. The first is 1989 3 SCC, page 293.
1989. USCC.
3 SCC 293. 293 millets. Please give copies, right?
Thank you. Dwarkadas.
This is Dwarkadas Marfatia and Sons versus Board of Trustees of the Port of Bombay.
Sitting on the list.
At the Bombay Port Trust.
You are in the list of candidates.
Paragraph. If my lords kindly have page 305, paragraph 25.
35.
25. 25. My lords have it. If my lords have it, may I read para 25 minutes? Therefore, Mr. Chiani was right in contending that every action activity of the Bombay Port Trust which constituted state within Article 12 of the Constitution in respect of any right conferred or privilege granted by any statute is subject to Article 14 and must be reasonable and taken only upon lawful and relevant grounds of public interest. Reliance has been placed so and so, my lords, I'll skip this part. Where there is arbitrariness in state action, Article 14 springs in and judicial review strikes such an action down. Every action of executive authority must be subject to the rule of law and must be informed by reason. So whatever be the activity of the public authority, it should meet the test of Article 14. The observations and so and so minutes may not be relevant. Para 26 minutes. The High Court had relied on the observations of the, para 27. We are inclined to accept the submissions that every activity of public authority, especially on the background of the assumption on which such authority enjoys immunity from the rigors of the Rent Act, must be informed by reason and guided by public interest. All exercise of discretion or power by public authorities, as the respondent in respect of dealing with, well, it may not be relevant for our purposes, that they go on to. What we are trying to get home here is, Article 14, when you are creating an intelligible differential between a same group of persons, especially considering that, what was initially being said by us and, there was no explanation from the other side, but now it has come on affidavit, that respondent number 6, has both upstream and downstream interests. And the three dates which are very relevant, which was placed by my learned senior Mr. Shah, if I may just bring to your lordships 3 dates. My lords would kindly just take note, respondent number 5 was incorporated on 1/9/2020.
Yes.
The amendment, my lords, comes into place in 15/10/2020.
Respondent number?
5, my lords.
1st September.
1st September 2020, they are incorporated. The amendment, my lords, is brought in by the state on 15/10/2020, my lords. And, my lords, the NIP subsequently floated on 17/11/2020. These are the 3 relevant dates. It's almost like, my lords, in anticipation of a law being brought in, 3 members of those 45 bonded warehouse, my lords, decide to form a certain firm, which then becomes, my lords, the CBW. And the other very interesting part in this, which is also seized off by this honorable court at this moment, is, my lords, there was a single tender on the basis of which the CBW was settled with the respondent number 5. That is, my lords, the subject matter of, I'll just give the writ petition number, my lords. Give the writ petition number, simple tender. That we have also challenged before this honorable court, my lords, that there was a single tender on the basis of which this matter was settled with the respondent number 5. That is WPC number 182 of 2021. So when, my lords, it is almost like, my lords, in anticipation that some law would be brought in, a firm is constituted by 3 sets of people, my lords, and then they go in and through a single tender, the tender is settled with the respondent number 5.
Yes.
Well, it's just one last decision that we want to place, my lords. That's 1997 7 SCC, page 463. 463. You've given me 1954. I'm sorry.
See, in those times, the Supreme Court made authoritative pronouncement of the law.
Justice, that's very nice to hear. Actually, cited Justice Shobhoshaji Mukherjee's judgment, the exposition of the law.
Yes.
There was no reference to Gita, Shakespeare, Dickens, this, that.
With authority,
To
with
the point, exposition, the constitutional background, the policy, the reasoning, and the result. The style was totally different.
If you have erudition, you will have the language also.
That's right.
Now you get only quotations.
Quotation.
What has already been laid down earlier, my lords, that's reproduced. Well, it's I am relying on paragraphs 12 and 16.
(1997) 7 is 463. Proportionality principle.
This, my lords, is again on the doctrine. Para 12 and 16, my lords, may kindly just have a, I'll just very quickly just read it, my lords.
Witnessbury case.
My lords, have it at page 471. Down below.
Yes.
Well, this is the Wednesbury's case of 1948. The case is treated as laying down various basic principles relating to judicial review of administrative or statutory discretion. Before summarizing the substance of the principles laid down therein, we shall refer to the passage of the judgment of so-and-so, my lords. It is true that discretion must be exercised reasonably. Now, what does that mean? Lawyers familiar with the phraseology used in relation to exercise of statutory discretion often use the word unreasonable in a rather comprehensive sense. It has frequently been used and is frequently used as a general description of things that must not be done. For instance, a person entrusted with a discretion must so do to speak direct himself properly in law. He must call his own attention to the matters which he is bound to consider. He must exclude from his consideration matters which are irrelevant to what he has to consider. If he does not obey these rules, he may truly be said, and often is said, to be acting unreasonably. Similarly, there may be something so absurd that no sensible person could ever dream that it lay within the powers of the authority. In another, it is taking into consideration extraneous matters. It is unreasonable that it might almost be described as being done in bad faith, and in fact, all these things run into one another. It must be proved to be unreasonable in the sense that the court considers it to be a decision that no reasonable body can come to. It is not what the court considers unreasonable. The effect of legislation is not to set up the court as an arbiter of the correctness or of one view or over another. And well, it's the other paragraph wanted to place is paragraph 16, Millets. Again, Millets, basically reiterating what has already been laid down. In R versus Goldstein, Lord Diplock said that this would indeed be using a sledgehammer to crack a nut. He has described proportionality as a principle where the court is concerned with the way in which a decision maker has ordered his priorities. The very essence of decision making consists surely in the attribution of relative importance to the factors in the case. And here's my point. This is precisely what proportionality is all about. He further says, what is therefore needed is preparedness to hold that a decision which overrides a fundamental right without sufficient objective justification will, as a matter of law, necessarily be disproportionate to the aims in view. The deployment of proportionality sets in focus the true nature of the exercise, the elaboration of a rule about permissible priorities. Which is what, Malaj, I was trying to submit before your lordships yesterday as well.
Yes.
That the very objective of this law, Malaj, by the subsequent events on the admission of the state itself, shows, my lords, that this law, A, does not serve any purpose, my lords. B, they now realize that they have indeed created a monopoly, which they try to set to naught by saying that we'll create a second CBW.
Yes.
Which one?
In that earlier matter,
54.
you just had the special officer
Copies from the court.
shall be paid for the ad hoc remuneration of how much was paid in the beginning, 25,000, in the same manner as paid earlier.
Some more? Yes, for the
Yes, please.
let's. Court's copy.
Another 25,000. He's got 26. Then again, in the matter will come and say,
Court master. Look, just one last decision. This is 1954 1 SCC, page 1.
Vivian Bose. Vivian Mukherjee. Vivian Mukherjee. No, Vivian Mukherjee. Judgment of Vivian.
Let's may kindly have page 9, paragraph 7, Malaj.
You have 7.
The first part is on the facts of this matter.
No.
My lords have it. May I just read? The first part is with the facts, Millets. It is not disputed before us that coal is essential commodity under the essential so-and-so by virtue of the delegation of powers of the central government to the provincial government, Millets. We can skip all that. 1, 2, 3, 4, 5. 5 lines from the bottom, Millets. The paragraph, middle of the paragraph, Millets. The sentence starts with all that is necessary is that these provisions should not infringe. I'm sorry.
9 you said, sorry?
Para 7.
Oh, 7, sorry.
Let's, my lords have it.
yes,
All that is necessary is that these provisions should not infringe the fundamental rights of citizens guaranteed under Part 3 of the Constitution. And if they impose restrictions upon carrying on the trade or business, they must be reasonable restrictions imposed in the interest of the general public as laid down in Article 19(6) of the Constitution. Nobody can dispute that for ensuring equitable distribution of commodities considered essential to the community and the availability at fair price, it is quite reasonable that to regulate sale of these commodities through licensed vendors to whom quotas are allotted in specified quantities and who are not permitted to sell them beyond the prices that are fixed by the controlling authorities. The power of granting or withholding licenses or of fixing the prices of goods would necessarily have to be vested in a certain public officers or bodies, and they would certainly have to be left with some amount of discretion in these matters. So far, no exception can be taken, but the mischief arises when the power conferred on such officers is an arbitrary power unregulated by any rule or principle, and it is left entirely to the discretion of the particular persons to do anything like when they like, without any check or control by the high authority. A law and order which confers arbitrary or uncontrolled power upon the executive in a manner of regulating trade or business in normally available commodities cannot be held to be unreasonable. As has been held in so-and-so, the phrase reasonable restriction connotes that the limitation imposed upon a person in enjoyment of a right should not be arbitrary or of an excessive nature beyond what is required in the interest of public. Legislation which arbitrarily or excessively invades the right cannot be said to contain the quality of reasonableness, and unless it strikes a proper balance between the freedom guaranteed under Article 19(1)(g) and the social control permitted by Clause 6 of Article 19, it must be held to be wanting in reasonableness. It is in that light of these principles that we would proceed to examine the so-and-so. What this essentially goes on to is again that same thing, Millets. Earlier regime, there was a level playing field, 45 players, Millets, having the liberty to negotiate with the distillers and Millets. That essentially led, Millets, that there was open competition between all the players. Now you create a body, you direct us to purchase only from that body, Millets. So at the time of bringing in this law, what was the reasonable explanation that was there before the government to bring in this kind of an authority, Millets? That is the only issue that has to be decided by Millets. We say, Millets, there was nothing available before the government, and now on their own admission, Millets, it comes in that probably the purpose for which that law was brought in the first place and an authority of another layer created of the central bonded warehouse, that itself stands defeated.
All right, Mr.
Millets.
So petitioner's part over.
Petitioners, Millets, I close my arguments.
Mr. Banji, on the next day?
Next day, my lord, I was suggesting because June I may not be there. 20 subject to my learned friend's convenience. 26, 27, and 28, my lord.
May.
May I, Smalat, request Mr. Banerjee, since your lordships have been hearing this matter with a frequency, well, if you can, my lord, even address your lordships virtually and finish it in the month of May.
No, I am not agreeable, man. I'm sorry. My learned friend addressed my lord for 8 days, and now he wants me to address your lordship virtually. This is not fair, man. I may not take 8 days, but physically, but I'm entitled to argue as many times as my learned friend said.
Why can't you
No, I'm not saying that.
No, not
Mr. Banerjee appreciates the natural beauty of this place also.
That's right.
Enjoys it.
My learned friend has better places to go, I'm sure.
And his
across the seas of the
arguments are enhanced and qualitatively better.
It's always a privilege to come here before my lords, and it's a beautiful place to visit, my lord. I mean, I don't want to sit in some. I understand Mr. Shah has many good reasons to not leave.
Mr. Banerjee, if you could choose dates before 24th May.
I could do 21st, 22nd, but I think my Advocate General has some difficulty between 21st to 23rd. That's my problem.
If
I understand the advocate will be available in the month of June. So,
Mr. Advocate General does matters frequently online, he can be online. He can join us. Subject to his.
Malad, I make it clear to Mr. Shah. When Mr. Shah is willing to sit for his entire annual vacation and work, and tells me that this year of his life he sat for the entire puja vacation and work, then my learned friend will tell me to work in the month of June. Otherwise, till such time Mr. Shah, in a friendly note, gives me that note, I am not bound to listen to this request.
I think they can
For
only.
his client's sake, maybe, but definitely not.
Advocate General 21st, 22nd?
Mr. Shah will tell me which year he sat the whole month and worked. I'm sure he has.
21st, 22nd, 23rd.
All right.
Very well.
Grateful, very
It
great.
gives me a little, maybe starts a little, it gives me a little more time. I'll be able to
All right.
press whatever you wish.
Mr. Paul concludes his argument. Full stop. Yes, yes. Arguments on behalf of International Spirits and Wines Association of India and Association of Meghalaya Bonded Warehouses are concluded. List these writ petitions on 21st and 22nd May
And 23rd.
and 23rd May, marked at 12:15 p.m. or until exhaustion of the regular list, whichever is earlier, to hear the state of Meghalaya.
Deeply
To hear
obliged.
learned counsel for the state of Meghalaya. All right.
Deeply obliged. I'm sorry I could not oblige Mr. Shah, who I normally would have
No,
not.
no, no, I am very happy with the month of May. Grateful.
All right. I make it clear. On the above dates, learned counsel are free to join the hearing physically or online, whichever is suitable. Great for them.
Grateful to him.
I'll oblige.
Yes, please.
Item number 1 to 5. My lord, Mr. Khurshid is in the waiting room. He's trying to join. I
You
will-
start, he will join.
My lord, we are filing the written submissions.
Yes, please. Yes.
Introducing interpolations, etc. Look at that. If your lordships would be kind enough to look at the written submissions, which are fairly copious.
Yes.
Look, may I request your lordships to pick up those documents? There were 3 documents. Document number 1, and that is basically what I have put in the narrative in this written submissions. Your lordships have looked at the document number 1, which relates to Jowai subdivision.
Document number 1.
On the last occasion, we had given some loose sheets. Document number 1, document number 2, and document number 3. It must be.
Yes.
Similarly, if your lordship would just look at these 4 columns, the last column, the 4th column, the last column is not that important because that gives finally the marks that have been recorded in the merit list. And the first column is names in the merit list. And so if your lordship will see number one in the merit list at page 194 has got 45 marks.
Yes.
So that's how this goes. So the first column is reflected in the last column. Now, what is critical for your lordships to examine is the second and the third columns. My lords, the third column, the third column, which is at page 204.
Yes.
My lords, that the third column is a column in which all candidates who have appeared are written in the list with whatever marks they've got, And my lords, if your lordships would just be kind to look at these pages, because that gives the full picture. If your lordship will just look at page 404, at page 204 or 205, 205 gives the entire list. 205, 206. So if your lordship will look at any page, 204 or 205, If your lordship look at page 205, all the candidates who have applied, their names are there, and the grand total of their marks is given at the other end of the page.
Yes.
And my lords, this is a tabulation that is done at the end of the day of interviews, and your lordship will see this is signed by all the members. All the members have signed it.
Yes.
So, my lords, just as an example, your lordship will see at page 205, candidate number 30. That candidate is Sri Newbang Ting. This very candidate, your lordship will find at page 197 at item number 6, is same candidate. In 197, item number 6. This is just to explain how your lordship will relate each of these lists. So your lordships have seen at page 205, item number 30, candidate number 30, the grand total marks are 45.
Yes.
At page 197, this candidate appears as item number 6, serial number 6, with the same 45.
Yes.
And then, my lords, in the final merit list that's drawn up at page 194, at 194, this very person is at item number 1, serial number 1, the same candidate. That's just to show the link between each of these lists. In the normal course, this is what it would be. But because there are allegations, I must explain how those allegations can be responded to.
He's item number 1.
He's item number 1. He's number 1 there.
194?
194. I'm grateful. You may take it, my lords, that we've done this exercise for everyone, linking them from the first sheet, which is 204, 205, to the second one, which is 197. Finally, with the last list, which is the merit list, which is 194. We've done this for all the candidates. I'll explain, my lords, where the point that can be raised against me is that if someone interfered with the marks in 204, 205, if somebody interfered with marks in 204, 205, they would also have to interfere with the marks at 197, because it's those two lists that I showed your lordships has the link between those two lists. So there would have to be interference in both lists, the first one as well as the second one. So your lordship may look at page 205 and page 197. If somebody was interfering with 205, they would have to interfere with 197 as well. Otherwise, 197 reflects what 205 was. And both these lists have been, your lordship will see 197 is also signed by all the selection committee members. And the cutoff, my lords, then, therefore, looking at this list, looking at the list at 197, the cutoff was kept at 39 for wait list, and above 39, people who got 40 were treated as having been selected and were put in the merit list. So if your lordships will come to page 194, page 194 are people who have got 40 marks or above, and then at page 195 are those who've got 39, just short of selection, 39, and they are put in the waiting list.
Page?
At page 195, well, the waiting list is at 195, and the selected people are at 194, which your lordships have seen already. So, my lords, if whatever has been believed, its impact can only be that someone who has 39 might have been made 40. Somebody who had 40 might have been made 39. But no general interference could possibly happen in the manner in which the CBI has placed the case before your lordships. So my argument, my lords, is that for liability, criminal liability, there has to be actus reus and there has to be mens rea. I've given arguments in the written submissions about there being no mens rea, but my arguments are fortified by saying that there is no actus reus, because the charge that has been brought and the charge that has been framed indicates that there was complete random changes of marks which couldn't have been done because the sequence of 3 lists that couldn't have been done, they would have been caught out immediately. And nothing like that has been placed as the material on which the learned trial court has come to the conclusion that this is a triable case.
No, the documents where interpolations were allegedly made, those have been produced by you.
What they've argued is, if your lordships go back to 2004 and 205, if your lordship may go back there, what has been alleged is that there is interpolation has been done by using whitener liquid. So the charge that the allegation is that after people have signed, the marks have been changed. But if
on these sheets, well, this
is the allegation. This is the allegation because none of the selection committee members have admitted to being under influence or under pressure to mark according to the wishes of the accused number 1. None of them have said so. Even
yes.
So accused number 2, of course, will argue for himself before your lordships. But my lords, the sum total of this sheet 204-205 is, the allegation is that the marks in this sheet have been changed. That could only be done after the 5 or the 4 committee members had signed. And if there are marks changed in this list, then, as I said to your lordships, the marks would have to be changed in the list on page 197 as well. So because 197 is also signed by the same selection committee members. So the change could not have been done only in one list. The change would have to be replicated in the second list as well. And the second list, this is important, my lords, the second list at 197 is a list only of those who've got 39 marks and above. So it can't be that somebody who's got 26 marks is suddenly put as 40, somebody who's got 35 marks is suddenly put as 40, which is what the allegations were. There was large-scale manipulation, there was large-scale scam, and this is what was happening, and therefore all this is a matter of criminal liability and a matter of trial. But at least the material must be there, my lords, the material must be there. They should have at least said that the changes that have happened are only between 39 and 40. So that somebody who was almost in on merit has been pushed in by being brought from the wait list to the merit list. Otherwise, nobody who hasn't reached 39 on their own and on merit could have been considered. My lords, this is an important factor, and what I am saying is that the very actus reus is missing. And if there is no actus reus, then to look at mens rea is not acceptable, is not permissible. And certainly, various arguments that I have made, there's no mens rea. Well, in totality, the story in totality, it's some public representatives gave lists and slips to say, please help so-and-so, please help so-and-so. The accused one, who was the minister, has also written on those slips, please help, please bring up, please help, etc. That may well be so, that may be proper or improper conduct, but there is nothing that indicates that by her saying, please help, those persons actually have physically been helped, and therefore the link between actus reus and the mens rea has been established. Well, this is essentially the argument that I make on merits. Well, just show your lordships just one document as well. That's document number 3. There was the loose sheets that your lordships had, document 3.
Yes.
Well, this is just to show that there's no pattern. There's no pattern. If somebody was instructing, if somebody was dictating, if somebody desired something to happen, there would be some pattern. But your lordships will see in this document, there is the name of Mr. R.C. Lalu, a total number of 37 in the list that the slips that were available that had been produced by the CBI. If your lordships will see, out of the 25, 13 are not selected. That's right on top, my lords. 13 are not selected. 1 is selected without tampering, without any allegation of tampering. 6, of course, have been selected where there's an allegation of tampering. But there's no pattern. If you Lordship go to the number, the second one, Mr. Dhar. This is the largest number in which it could be said that there is some issue. Out of 29, 2 have not been selected. 2 have been selected who have not had any tampering. And then there are 25 who are selected but also tampered. The Lordship will then look, this at the bottom of this is Annexure 8, which comes from page 103 of the paper book. Interesting to see this, Malaj. Now here is first is a group of people who've been selected. And in their cases, there's an accusation of tampering as well. But there is no note given for them. There's no note which says this has to be done. It could be argued that there is some tampering and they've been selected, and these are 21 people. If your Lordship will see over the page, these are 21 people. So there is no note. These 21 people have been selected without a note of the accused. If the accused is being allegedly said to have written notes for the tampering purposes, these are 21 people where there is no note, but tampering has happened. Now, of course, Malod's accused number 2 will explain this further. Then, Malod's, the second group is those who've been selected, but there is tampering and there is a note as well. These are 11. There are 11 where there's a note who've been selected and there's tampering. Then, my lords, the next group is people who are selected. They've been selected. There's no tampering and no note. They've been selected. Then, my lords, the bottom one, the last group is those who are selected, no tampering, but there is a note saying, please help them, please help them. That's the next group list. So my argument, my lords, is that this is completely random, and any scientific principle of randomization could apply to say that there is no clear direction which has been followed and which has dutifully been applied, causing these people who were not qualified to get in and people who were qualified to be removed. This read with the argument that I made before your lordships with those papers. Your lordships may please examine. My lords, very quickly, my written submissions, I'll take only 2 minutes on my written submissions, because your lordships will have the opportunity to read them. My lords, I've given, in the first 2 pages, I've given a brief narrative of what the factual position was. If your lordship would be good enough to keep the petition open, the order on charge, impugned order on charge, if your lordship will just keep that in front. This is page 44. It begins at page 45. There is a general narrative, page 45 to page 48. I am not anywhere, accused one is not anywhere shown to have directly interfered in any manner, but in all fairness, at page 50, paragraph 12.6, what is said is this, my lords, and I urge your lordships to consider whether this can be sufficient for framing of charge. The prosecutor submits that there is sufficient evidence on record to show that accused one received recommendations letters from public representatives. Accused one shortlisted the candidates and directed accused two to select them. The materials on record reveals that A1 and A2 had entered into a criminal conspiracy for manipulating, forging the original score sheets. Well, where does all this come from? No material has been placed. No material has been placed. I am candidly admitting that she received slips. She passed those slips on to A2, but nobody has ever said that she insisted or pressurized A2 to act upon those slips.
What was the praise in your application?
I'm sorry, my lords.
What was the praise in your application before the trial court?
Well, before the trial court was for discharge, I said that there's no material for framing of charge on this basis. And my lords, there are 2 or 3 legal arguments as well on forgery. They have charged me on forgery, and I've said that Sheila Sebastian is a clear case of the Supreme Court, where the forgery can only be brought about against the person responsible for forging. It cannot be for anybody else. And I've got that in the note as well, my lords. I have that in the note. So both on legal arguments, and the learned judge said this is for trial. But something that is stated by the Supreme Court as the law of the land does not need and require to go to trial, and on the trial for it to be reflected. If it's the law of the land, it applies at every stage. It applies at the stage of framing of charge, and no charge can be framed which is directly against and contradicts the judgment of the Supreme Court. So, my lords, what I have argued is that this continues throughout, and if your lordship will see page 53. Well, I'm sorry, page 52. I will just show in paragraph 13. Paragraph 13.3. Just to complete the story, sixth or seventh line, the score sheets of the qualified and eligible candidates were prepared and signed by all members of the board before it was sent to A2, which only goes to show that A1 had no hand in the selection process of the candidates. My lords, this is what I had argued, and this has been completely overlooked. Then, my lords, 13.4, my argument is noted, but it has no effect on the final judgment. About the 6th line again, my lords, the argument has also been advanced in the prosecution case is not that A1 had tampered the marks, but it is alleged that A2 has tampered the marks, replaced the score sheets, destroyed the original score sheets. The entire prosecution is directed at A2, is what I'd argued. And I've said that A2 would argue.
I've got all your points, Mr. Khurshid. I've got all your points. The only question is whether to quash it or send it back to consider a discharge of your client.
Lords, I'm grateful. Your lordships will consider it. I'm most grateful, my lords. Most grateful.
What is the situation there? Adjourned till
30th of May, madam. 30th of May, but no witnesses have been summoned, but the matter is just listed for us to apprise what happens here. In case the matter is heard before that, then the trial may proceed or whatever audio flows from my lord.
30th of May. We will hear it before that. Mr. Khurshid, when would it be convenient for you?
Well, it's 30th of May is fine. As I go, I'm next available.
You will be making your arguments now, madam. When?
I have two apologies.
For the accused too.
A2.
A2.
Basically adopting what my learned senior has argued, there's 2 aspects we need to point out where A2 comes in, Millets.
Mr. Khurshid, are you going out on a vacation now or? you're here.
My lords, at least till the 30th I'm there, but to your lordship's convenience, I can accommodate. for us.
30th. Till 30th, you're.
Yes, I'll be here. My lords.
Nineteenth, 20th at 12:30.
Balance.
Have you fixed
Please, my
another?
lord.
Which that's spirit? Huh? He? What's it here? What?
Madam, may I request for a week after that, Madam, 26, 27?
22nd, 23rd?
The lords have also fixed the other matter. The term of time of permit.
Anyway, we will take it up at this time. It doesn't matter.
After.
Or it could be before that also.
I was praying for 26, 27, Madam.
26, 27, this court may not be available. That is it.
Prior to the 24th.
Give you some dates.
So this is your Google Calendar.
We can do it 26, 27.
22nd, you have Atlas also.
20th, 21st, which matter you said has been fixed?
20th, you have this.
21st?
You have this.
21st.
20th, we are keeping it at
20th.
marked at 1 p.m. Mr. Salman Khurshid, learned senior advocate, concludes his argument. List these applications on 20th May, marked at 12:45 p.m. or until exhaustion of the regular list, whichever is earlier. To hear learned Deputy Solicitor General appearing for the state. Sorry?
Yes.
No. To hear Mr.
Paul.
Mr. Paul, learned senior advocate Paul, the accused number 2. Thank you, Mr. Paul.